Good afternoon. I am Dr. Neeru Gupta, Assistant Professor, IIMT College of Law, Greater Noida. My topic is Indian Evidence Act 1872 and exhaustive overview. Firstly, I am discussing about the introduction of evidence. Evidence is derived from the Latin term evidere, which means to show clearly, to make plainly certain, to ascertain, to prove. Some different writers say give the definition about the evidence. Taylor says the word evidence includes all legal means exclusively of mere arguments which lend to prove or disprove any matter of fact, the truth of which is submitted to judicial investigation. According to Section 3 of Indian Evidence Act, evidence means and includes oral and documentary evidence. Here, oral evidence refers to all the statement which the court permits to be made before it by the witness, and such evidence should be related to the matter of fact under inquiry. Whereas documentary or written evidence refers to all the electronic records presented before the court. Kinds of evidence. Two types of evidence, direct evidence and circumstantial evidence. Direct evidence. Direct evidence is considered as imperative evidence for deciding the matter in issue. It directly proves or disproves the fact. In such evidence, a specific fact is established directly without providing a reason to connect to the fact. One hardly needs to point out the illustration provide as the evidence of witness in court is direct evidence as opposed to a testimony to a fact suggesting guilt. Such evidence is real or clear evidence of a fact that requires no thinking or consideration to prove its existence. However, relying on the evidence completely without any reasoning to prove its existence can be considered as a drawback as well. Circumstantial evidence. Circumstantial and indirect evidence refer to evidence which prove the fact in issue by providing other facts, that is, indirect facts, and then proving their relevance. A satisfactory conclusion can be drawn from such evidence by relating a series of other facts to facts in issue. Such indirect facts must have been associated with the facts in issue and have a cause and effect relation. Documentary evidence. Document is defined in Section 3 of Indian Evidence Act. Documentary evidence refers to any matter described or expressed upon any circumstantial by means of letter, figure, or marks, or by more than one mean which can be used by recording the matter. Such evidence is produced in the form of a document in order to prove a dispute fact, essential or subject matter of documentary evidence are as follows. How the contents of document are to be proved, how the document is to be proved to be genuine, how for and in what case the oral evidence is excluded by documentary evidence. Hearsay evidence. Hearsay evidence refers to evidence which the witness has neither personally seen nor heard. It is just reported by the witness and considered to be very weak evidence. In other words, it refers to something that others have said or heard. There are no set standard to receive such evidence, provide it has reasonable credibility and nexus. In the absence of such credibility and nexus, it is difficult and dangerous to act upon such evidence. Thus, such a piece of evidence cannot be used if its credibility is not assured and questioned. Now, the necessity of the rule of evidence. The other one is if there are no rules at all, then no case will ever be decided. It would take years before the simplest case is decided and justice would become a monarchy. Further, if you leave it to the court to decide on each occasion what matters are connected with the matter in controversy and therefore should be looked into by the court. There will be great uncertainty as to relevant matters, depending upon the patience of the judge. Therefore, the rules of evidence are absolutely necessary both from point of view of time as well as of certainty. Evidence as a part of procedure law. We have gone through the points that rule of evidence are necessary. We have also seen they play an important part in the course of trial, whether a criminal or civil case. Since it deals with the procedure, it is under the category of law referred to as procedure law or adjective. In contrast to substantive law, which deals with rights and liabilities, under what condition a certain right exists in a certain person, under what condition is a person subject to a specific liability. Law of evidence as a part of procedure law. The law of evidence, however, is part of law of procedure, the procedure which a court has to follow. It is said that the law of evidence is the law of form or lex fori. It is a matter of convenience, which means in the evidential procedure, the court must follow those procedures of country of the court. The foreigners cannot insist upon their law of evidence being followed by their countries. Function of evidence law. The law of evidence is of great importance of judicial proceedings. Below are some of its functions. First, it prescribes the manner in which relevant fact may be adduced in a court, either by way of oral or direct evidence, or admissible hearsay evidence, or judicial notice, presumption, or documentary evidence. The law of evidence determines what facts may or may not be proved in a court of law. It does this by excluding those facts which may not be proved. The law of evidence elaborately lays down the competence and privilege of witness. It stipulates rule on who qualifies to be witness and who does not. It determines the question to be asked to the witness and the manner of doing the same. The law of evidence also sets down the manner of proof in court by witness or not, subject to examination in chief, cross-examination, and or judicial notice, presumption, admission by production of material, objects, and documents. Now we talk about the basic concept of law of evidence. There are certain basic technical terms used in the law of evidence. The meaning of some of terms can be easily understood from the use of ordinary language. Others are silently technical. What follows below in a definition of some of the most crucial terms which are applicable in day-to-day application of the law of evidence. Facts. The Kenya Evidence Act defines a fact flow. Fact means anything, state of thing, relation of thing, capable of being perceived by sense, any mental condition of which any person is conscious. Fact in issue. A fact in issue means any fact form which either by itself or in connection with other facts, the existence, non-existence, nature, or extent of any right, liability, or disliability, asserted or denied in any suit or proceeding necessary follows. Therefore, a fact in issue may be a fact that one party alleges and the other party controverts. Relevant fact. A fact is relevant if it has a probate value, that is, if it tends to pursue a court of law of the probability or possibility of alleged facts. Evidence is said to be relevant to a case if it has direct connection of the fact in issue and can be used to prove or disprove the fact. Prima facie evidence. It is the kind of evidence which normally necessitates a finding that a fact has been proved if such evidence is not rebutted. Direct or indirect evidence. It means which tend to show the existence of a fact in question without the intervention of proof of any other fact, and it distinguishes from circumstantial evidence, which is often called indirect. Indirect evidence, on the other hand, refer to circumstantial evidence or evidence of relevant fact which we have already addressed above. Oral evidence. These are statements made by witness in court. It refers to a person testimony offered to prove the court of matter asserted. Probable evidence. This refers to heuristic evidence and is at time referred to be a probable rule evidence. Primary and secondary evidence. Primary evidence is the best evidence. It is evidence of highest quality available as measured by nature of the case rather than the thing being offered as evidence. Secondary evidence is the documentary evidence. Is the original document is available, it must offer rather than a copy of original document. Secondary evidence, that which is inferior to primary. Thus, a copy of an instrument or oral evidence of its content is secondary evidence of instrument and contents. Opinion evidence. This is where a witness is called to testify as to his or her belief, thought, interference, and condition concerning a fact or facts. It is a conclusion formed from observable and mental impressions. Proved. A fact is considered to be proved when the court, after considering all the evidence after the trial and proceeding, either believes the happening of the case in such a manner as it is expressed, or if the court makes a probable interference beyond reasonable doubt, then believes that the existence of the case in such manner as it was explained. Disproved. A fact is considered to be disproved when the court, after considering all the evidence after the trial and proceeding, either believes that is does not exist as explained, or if the court makes a probable interference beyond reasonable doubt and does not believe the existence of case in such a manner as it was explained. Not proved. A fact is called not proved when the facts are in a circumstantial condition that they are neither proved nor they are disproved. Presumption. Presumption generally means the process of ascertaining few fact on the basis of possibility, or it is consequence of some act in general which strengthens the possibility, and when such possibility has great substantial value, then generally facts can be ascertained. A presumption in law means inference which are concluded by the court with respect to the existence of certain facts. Section 114 of Indian Evidence Act specifically deal with the concept that the court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course, natural event, human conduct, and public and private in their relation to the fact of particular case. May presume. It is a condition when the court enjoys discretionary power to presume any certain few facts and recognize it either proved, or may ask for corroboration evidence to confirm or reconfirm the presumption set by the court in its discretion. Section 4 of Indian Evidence Act provides that a fact or a group of facts may be regarded as proved until and unless they are disproved. The concept is defined under Section 4 of this Act that may presume deal with rebuttable presumption, and it is not a breach of jurisprudence. Shall presume. It denotes a strong assertion and intention to determine any fact. Section 4 of Indian Evidence Act explains the principle of shall presume that the court does not have any discretion power in course of presumption of shall presume. Rather, the court has presumed facts or groups of facts and regards them as if they are proved until they are disproved of the other party. Conclusive proofs. It can be considered as one of the strongest presumption a court may assume, but at the same time, the presumption are not completely based on logic. Rather, courts believe that such presumption are for the welfare or upbringing of the society. With regard to conclusive proof, the law has absolute power and shall not allow any proof contrary to the presumption, which means if the fact presumed under conclusive proof cannot be challenged, even if the presumption is challenged on the basis of probating evidence. Res geste. Doctrine of res geste. The doctrine of res geste is expressed under Section 6 of Indian Evidence Act in the following ways. Facts which though not in issue are connected with the facts in issue so as to form a part of same transaction are relevant whether they occurred at the same time or place or at different time and place. Essentials of res geste. The statement made should not be an opinion, must be a statement. The statement should not made be by participant of the transaction. The statement should have enough information to explain or brief about the incident. The statement made by a person or act, the person should be in the main transaction. Ratan versus Queen is the case law of res geste. Uttam Singh and state of Madhya Pradesh, also the case related to the res geste. The facts of this case, the child and the victim were sleeping together at the time of the incident, and he suddenly awake due to the voice of axe and screamed for the help by taking the name of the accused. Just after the call for some help, his mother, sister, and other witness come there. The court found this evidence to be admissible as the act of the child, and the accused was of the same part of the same transaction. Motive, preparation, and conduct. Section 8 of Indian Evidence Act talks about the importance of motive, preparation, conduct in various cases. And it is a well-known fact that motive and preparation and among the first act before the conduct. Therefore, Section 8 explains the importance of motive, preparation, and conduct, where there are no direct evidence and the facts are proven on the basis of circumstantial. Conspiracy. Conspiracy means few people come together to do an act with common intention. So, in the same context, a criminal conspiracy is the act of at least two or more persons to do an act which is not authorized by law, an illegal act, or to do a legal act by illegal means. Criminal conspiracy is a kind of partnership in crime, and even every member of such partnership must join the partnership by mutual agreement for execution a common plan. Essential features of criminal conspiracy. There should be a reasonable ground to establish a conspiracy. There should be at least two or more persons to form a conspiracy. There should be common intention of all the conspirators. Alibi. Section 11 talks about the alibi. The word alibi is derived from the Latin term which means elsewhere. Evidence Act explains the concept of facts not otherwise relevant become relevant and makes the provision as to defending ground over the ground for the accused. The simplest meaning of this section is the condition when the incident took place and the accused is charged for the incident, then he may make defend him on explaining that at the time of incident he was not present at the location, although previously it was not relevant for the court to know that where he was. An investigation showed that he committed the crime, but his explanation that he was not at the place of incident make the irrelevant fact a relevant fact. The important part of Section 11 of Indian Evidence Act is that the rule is only accepted in the course of admission of evidence and no other statute provides such rule. Thank you.